Good morning, everybody. Jay Womack, founder and CEO of Infinity Workforce Solutions. Thank you so much for joining us today. Our webinar will begin in just a few minutes. I appreciate y'all sitting on hold. While we're here waiting for everybody to jump on, I want to give a special shout out to our existing clients that are here with us today. You are proving to your entire workforce that safety is your number one concern, it's your number one priority, and we appreciate that because we are very, very good at delivering training for safety, for orientation, for ongoing corrective action, and you obviously have taken the jump into the company right now and you're using it, you're saying that your people are valuable to you, and that's exactly what we want. That's what you want. That's what your people want to hear. So we do have all the answers. We know exactly what we're doing in web-based training. We've been doing this for 15 years, but I have a special offer today for our prospects that show up. We'd like to offer you a 30-day free trial using our system completely. See what it's all about. See if you like using something like this. You know, remote training has jumped to the forefront of the world. In the last 90 days, the world has shifted, it's changed. Remote training, we're the experts. We know more about remote training than virtually anybody in the entire, world universe. So I want to offer the 30-day free trial. Time offer is limited. Yeah, we can't make this go on forever. I wish we could. I'm even going to throw in a CSR rep, a client service rep, that can make this thing hum for you, get user activity up on the system, because that's the key, get your people to use the system. I don't care how many bells and whistles you've got, if they're not going to use it, it's not going to have an impact for your company. And at the end of the day, that's what we're all about. We want to see your top line and bottom line improve. We want to see your safety record improve. That's what we do, and we do that better than anybody out there. Thanks for sticking with me. In the meantime, it's what you came for. It's the webinar. So, Mark, if you're ready, I'm going to hand it over to you.
Good morning, everyone. And thank you very much for that offer, Jay. And it's great to hear your support for our industry and the challenges that we're going through, both short-term and long-term. So thank you very much for that. We've got a tremendous segment today on a issue that's on everybody's fix-it list, which of course is avoiding or managing through this issue of nuclear verdicts. So my name's Mark Ray. I've got 35 years in the trucking industry, the last 28 with Frozen Food Express right here in Dallas, Texas. And one of my responsibilities have been in the involvement of lawsuits and defending truck crashes all across the United States. And today we have joining us a defense attorney that I've worked very closely with. His name is Peyton, and I'll introduce him a little bit more in a minute, but I will certainly validate that I've had that pleasant experience, if there is a pleasant experience in defending lawsuits, of hearing a judge read your motion for summary judgment has been approved. Those don't happen very often, but it has happened with a coordinated effort, and Peyton has got a lot of experience in that. So also, I will tell you that Peyton is a CDL holder and has his own truck. I've had the opportunity to ride in his truck, but he wouldn't let me drive it. So maybe one of these days I'll get to drive it. So Peyton, you want to introduce yourself here? And I understand I'm going to make a declaration that I think you might have the record for getting the most summary judgments on truck crash lawsuits, maybe in the entire industry. So thank you very much for what you do for us.
Well, thanks for having me, Mark. It's great to see you again. Next time, I promise I'll let you drive. But that my old 359 doesn't turn very well, and she's stretched and slammed, and it just she's a little bit difficult, but a lot of fun. Yes, sir. In terms of background, I've been driving rock buckets since I could walk. I should say cattle trucks out on the ranch, paid for school by doing hauling rock. But the key with summary judgments is that you're getting your case dismissed, or the case against you dismissed, long before you have to go to trial. So you save yourself a lot of money. And also, even if you don't win the pre-trial dismissal motion, it's a good way to educate the judge on just how weak the plaintiff's case is. So I try and file one in just about every case, and we've met with more than our fair share of success.
Well, that's a breath of fresh air. So just to kind of set the tone on this nuclear verdict issue, I know most of you have seen the ATRI research paper that was recently submitted, and just to summarize it, it said that since 2000, the average verdict for truck crashes is up 900%. So when people ask the question, why are insurance premium rates going up and why are renewals difficult, it's because of these nuclear verdicts. And what we're going to talk about today are a couple of things to think about in avoiding or preparing yourself ahead of time to keep you out of that nuclear verdict world. So I've got a couple of questions before we get into our formal presentation. The first one is on the avoidance of nuclear verdicts. Again, nuclear verdicts are multi-million-dollar verdicts. So the question is on awareness training. You know, the repetition of getting training and awareness of events in front of your drivers on a regular basis. And of course, having that training available and participation in that training can be different. So my question, and we're going to have a poll question come up, but my question for Peyton is, does participation in assigned training have an impact on your ability to defend a lawsuit? And we've got the poll question while he's answering. What percentage of your drivers complete their training assignments? So, Peyton, you want to give us a run at having training and training participation rates?
Mark, that's a fantastic question, and it dovetails nicely into the whole nuclear verdict question, right? Because the number one tactic that these plaintiffs' lawyers try and take is they try and establish that it's not just the wreck itself, that something this driver did was indicative of a lack of training or a lack of proper supervision by the company. Now, obviously, as professionals in the industry, we all know that's bogus, but that's the argument they try and make to the jury. And they try and inflame the jury and make the jury mad at the trucking company by showing where the driver didn't go to this training or that training, and they completely ignore the fact that the driver was a qualified driver and more than capable of being out on the road that day with that load, regardless of whether he went to training, additional training or not. But, you know, when I look at it across the industry, I think that probably 70% of the training that's offered by the company is able to be proven to have been completed by the driver. And that's one of the things that y'all's program really helps, is that if I could just go and, or the safety director could go and simply request copies or proof that a specific driver has completed training and identify what training occurred, when it was completed, and how it was completed, it makes my job much easier. Because again, my goal early on is to try and get the direct claims against the company for negligent hiring, supervision, and training thrown out as early as possible.
Okay, that's so a common question in discovery is going to be, what are your drivers participating and what percentage of those? Colin, do you have the results of that poll? Well, we got 24% that say 100%. That's the answer you want. But we've got a pretty good between 75 and 99%. So the fact is, making your training simple and easy to access and not a burden can certainly help with the defense of a nuclear verdict. So the second question I've got is on post-accident procedures. Those of you that were listening a couple of weeks ago when we had the Major Nordlow and CVSA was very clearly defined that car truck accidents, 70% of truck car accidents, the critical reason for that crash rests with the car. which means 30% of those truck car crashes are defendable. So the question I've got, and I know you've seen a wide variety of post-accident actions or lack of actions or decisions or statements or things that are done right immediately following a accident that has an impact on your ability to defend a lawsuit. So can you give us a little insight on how we can train and make our drivers aware of what they need to do on the scene of an accident immediately after an accident, fault or no fault? Peyton, I think you're on mute.
I am. I apologize. I am a huge fan of an informal post-accident procedure program. Okay, so other than we know if it's a reportable incident, transport or whatnot, we need to go get a drug test on that driver. Other than that, I like to see an informal post-accident policy. But what your driver needs to be reminded of is that he or she is the face of your company. And so to the extent that you've had a collision with somebody that isn't out to get you or isn't looking for a handout, if that driver is friendly, non-aggressive, things of that nature, it will fundamentally help us down the road. Compare that with a driver that is aggressive or angry or denying anything. You can create a scenario where that four-wheeler is now angry at you or your driver, and they're not going to want to resolve that case or maybe even think about not filing a lawsuit against you to begin with. They're going to do it because they're simply mad. So your driver has to know from the date you hire him and remind them during the course of their employment that they are the face of the company. They need to act like the consummate professionals you hired them to be. Number two, when that accident happens, if it is safe and only if it is safe to do so, that driver needs to get out their phone, and after they determine that they either need to call 911 and do it, or they don't need to call 911 because someone else already has, they need to take photographs that depict the path of travel where the car, how the car and how the truck traveled to the final resting point, take pictures of where the car and truck actually are, take pictures of any skid marks, things like that. Again, this is only if it's safe to do so. But those are the types of photographs that allow me or risk safety to come in and figure out what happened and why, and to corroborate the driver's side of the story. And it makes it much, much easier. The driver also needs to know, look, we're not going to go out and just volunteer a whole bunch of information. This is a tense or a, we've got a lot of adrenaline going through our system. Make yourself available to the police officer to answer questions. But you don't want to be aggressive about it, but just be available. Don't be defensive, but don't volunteer a whole lot of information. Number three, if there happens to be a camera in the truck, you might think about making, and the video footage is useful to the officer. We've had a lot of success with getting the officer on the phone, offering to make that camera footage available, and then sending an 8 or 10 or 15 second clip to the officer to show that it wasn't our fault.
So it wouldn't be a bad idea or action item for the listening audience to maybe simulate an accident with their drivers and say, what would you do? And then also as an ongoing awareness, assign this is the content, this is the training that you need, so that you more than likely will do that in the event you're involved in an accident. And that can make a big difference in a non-nuclear versus just a regular old lawsuit. So I would just encourage everybody, think about that. What are my post-accident procedures? Do my drivers know what those are? And how can I get that information to them so that they're ready? Okay, well, that certainly sets the tone for the presentation, and I will turn it over. I know you've got some dash cams and some war stories, so if we could pull up the PowerPoint. There it is. There's your truck. So take it away, Peyton.
Yes, sir. That is my old Pete. We trundle around the country probably 35, 40,000 miles a year to races and conferences and whatnot. A lot of fun to drive, but it definitely gives you a great opportunity to visit with drivers and whatnot when you're stopping at truck stops and spending the night on the side of the road, things like that. Because everybody's curious. When we find out you're a lawyer, they want free legal advice, which is good for everybody. But it's a lot of fun. Anytime you have a claim or potential claim, or even before you have a claim, and just planning down the road, because the cost of doing business these days is, potential crash and a potential suit. But you've got to hire the right team from day one. And you've got to hire an attorney that can win, not just try a case. And the reality you've got is a lot of people will tell you that they can try a case. A lot of people tell you they know trucking, and the reality is they simply don't. And trucking is one of those types of law that it's probably the most dangerous of any type out there, because you can get your head figuratively blown off with some of these judgments, some of these nuclear verdicts. So you got to know somebody hire somebody that knows trucking, that's likable, that knows the judge, and knows how to find the ammo you need to prove your case. And that ammo is going to be in terms of, one, proving that your driver was qualified, trained, and that at the end of the day, he didn't do anything wrong in this particular collision. The key is getting the company out as quick as you can if you get sued, and then being able to educate that judge early on as to the strengths of your case and the weaknesses of the plaintiffs. Next slide, please. Some of the things that will increase your risk for a particular case are going to be your venue concerns. We all know dangerous places in Texas, but there are places in Louisiana, the Bronx, and around LA and Bakersfield that are incredibly dangerous to anybody. And you've got to be incredibly aware of the potential for a large verdict, even parts of New Mexico and Arizona now. That you got to be careful going in that that case could be worth, instead of being worth pennies, it could be worth hundreds of thousands of dollars, if not more. So venue is one of the main concerns we look at when trying to decide how we're going to proceed in a case. We want to know if there are any of your initial indicators of a bad venue. That's going to be urban, lower income. You're going to look at the education average and the city leadership. Like it or not, most of your cities where you're going to have a more adverse or poor jury pool are going to be Democratic run. You've got to be aware of that going in. And Mark, I've got a courier here. I may have to go sign for something real quick.
Okay.
Give me 2 seconds. I will be right back, because my guard dog is letting me know. I'll be right back.
Sure. Well, when we talk about venues, you can't always pick the location that you have an accident. They happen across the board, but I can assure you the location and the venue has a big impact on the potential for a verdict. So if you'll go to the next slide. Well, let's talk a little bit about discovery. Discovery, most everyone probably on this call has been involved in a lawsuit, and you'll get a letter to preserve the documents, and they want everything. They're going to ask for everything, and of course, you can't generate documents post-accident. What you got is what you got. And the documents, the preparation of documents, the availability of documents, from my experience, has set the tone on how the lawsuit will progress, or whether it sets up for settlement. And it's a big issue. And specifically in our world of training, the ability to produce a document that says, my guy unfortunately had a wreck, but he was at night, but we have training on night driving that he completed. Here's the date, time, and place, and or intersections, or a lane change, or whatever that might be. And that certainly changes the tone of how these lawsuits progress. So, Peyton, you want to detail that a little bit for us?
Yeah, and so Mark, you hit on a couple of very, very good points. The key is, going back to the summary judgment issue, is that if you can convince the court that there is no there, then you're going to get at least a large part of the plaintiff's case thrown out. So what I like to do in discovery is don't fight about things that aren't important. I get requests that are an arm's length long, asking for everything under the sun. And we'll go through some of the obnoxious examples I get here in a few minutes. But I will try and produce evidence that the driver has been trained, because we all know that that driver was qualified as a driver from the day he got his license to operate that truck. As a matter of best practices, we might go through and provide additional training, and it helps to identify that and just produce it without any argument. And that's where your platform is so useful to us and us in the industry, is you can basically hit print or send and provide it. You can prove that the driver was trained on X, Y, and Z date. And then that way you avoid an unnecessary fight with plaintiff's counsel. Because what I try and do is I make sure that when I go into that judge, that I'm the most credible person in the room. And if I waste my credibility arguing over something that's not important, the next time I go in there, the judge is going to remember that. It's not going to be very happy. So when I get these requests for documents, a lot of times they ask for everything under the sun. And what I will try and do is I produce the things that are relevant to the case. That's going to be driver training, a qualification file, if you had a post-accident report, any type of those things that aren't privileged. I'll go ahead and produce those without a fight, because it doesn't hurt us. Typically, it's going to make us look good unless there's something unusual in there. But then I use that as ammunition down the road to prove to the court that there is no case, and plaintiff has to, basically has to take a walk on most of their claims, at least against the company. As you and I have explained.
Peyton, I guess just to ask a quick question or observation, I guess it's very difficult to defend a lawsuit when I don't have this, I don't have that, no, I don't have these documents, I don't know what you're talking about. That does not set the tone for a reasonable defense.
Yeah, and that definitely makes it more complicated, because you have these trucking experts out here that will say, well, everybody in the industry has an additional training program, but you can't prove it. And I get more concerned, Mark, when I have clients that say they conduct training, or they have a policy that says training should be conducted, but I can't prove the driver actually underwent that training, because now that opens the door to an argument. Well, Judge, they knew training was important, and yet they can't prove the driver actually did it. And here's the policy right here saying it's important and should be done. That's where I get more concerned, and it makes it more difficult for me to get the company dismissed from the case early on. And those negligent hiring, supervision type training claims can survive when they should have gone away if someone either had appropriately written the initial policy, or we could prove the training occurred. Another opportunity I see to help improve our case is when the plaintiff asks to depose our driver, our safety representative, or whomever. These depositions are a great opportunity to prove that there is no case there, and you do that by answering in a short and simple fashion, not providing any ammunition to the plaintiff in their case. But that does take a lot of work, as you and I have had the opportunity to do before. I mean, you sit down and you work through the potential questions and the answers, and the most accurate way to answer politely and succinctly. But those depositions ultimately are going to be the key to your case. And obviously that's sworn testimony, the same as if you're testifying in front of a judge or a jury. So especially, I mean, you've got to be right 100% of the time. You can't guess, you can't lie for sure. You've got to be accurate. And that's how you button your case up and prove to yourself and, to your insurance carrier and ultimately the judge and jury that, look, you didn't do anything wrong. You might also get a request for discovery that involves questions that have to be answered under oath. It's basically a written deposition. They're typically short questions, but all of these questions you really need to work through with your lawyer, because if this is particularly applicable to carriers that have insurance companies that have captive counsel or have specific attorneys that they use every time. Most of these guys they send cases to, they don't try a whole lot of cases, and they sure don't know the ins and out of trucking. And that can be a huge problem, because the way law firms a lot of times work is you get a partner that will take a case in because they've got a good relationship with the insurance carrier. And then that case is then actually handled and worked up by a much less senior attorney. And what we run into a lot, especially when I inherit cases that have come from a different firm, is cases that weren't worth a whole lot are now worth more because the appropriate steps weren't taken early on. What we see is that truck drivers and companies tend to just assume that the attorney doesn't really need to know X, Y, and Z information. Don't tell him or her. And the reality is that if that occurs, your attorney, even if they knew what they were doing on the trucking component, and it is unique in many ways. Even if they knew what they were doing, they can wind up at a distinct disadvantage because they told the judge one thing, but it wasn't 100% accurate. And some of these plaintiffs' attorneys know trucking far better than the actual defense attorneys. And that's where hiring the right team really comes into play. So if you have a young attorney or any attorney that asks you for the driver's qualification file, if you happen to have additional files on that driver, inform your attorney of that, and then make sure they know that you have these additional files. Because I've seen cases before where a company has a driver's qualification file, but because somebody only asked for the DQ file, that's all they got. They didn't get the employee file, they didn't get the write-ups, they didn't get other information. And so when the corporate representative goes in for deposition, volunteers, which you shouldn't do, but volunteer, somehow the plaintiff discovers that there is additional information out there, then they go to the judge and say, well, your Peyton's hiding it. And so if you've got an attorney that isn't asking all the questions, just to help them help you. And that's where it is useful to inform the attorney of, hey, look, this is the ins and outs of the trucking. And then if you, Mark, on your program, if you guys have the ability to produce all the training, just give your attorney everything. And if there's something in there that you think is a problem, make sure you tell the attorney that, but make sure he or she has all the information you have that they asked for. And
so
then,
it would be a fair statement to say that your ability to produce documents at the discovery phase puts the plaintiff's attorney in a decision mode on whether or not he's going after the nuclear or whether he says, I'm just going to settle this. These guys look like they've got their act together.
yeah, it depends on how much the plaintiff's attorney wants to invest in it. We've seen some of these plaintiff's attorneys that have won really big verdicts in other types of cases now start to turn their attention to trucking because they don't have any other ambulances to chase. And I'm being facetious here, but some of those guys aren't afraid to spend $100,000, $200,000 on expert fees, even though the case is worth a nuisance value. And it becomes very hard to talk to them in a logical fashion because they're just blowing money on a bad cause, and they either don't know or don't care, or they're trying to. It's like playing cards; they're bluffing on a bad hand. But yeah, if all your ducks are in a row, and you can prove the training, it's a simple negligence issue. Maybe our driver messed up, maybe he or she didn't. If it's a simple negligence issue, most intelligent attorneys that have a large caseload are going to look for other cases to pursue, and they're going to realize that they're never going to make. They're not going to get a nuclear verdict and knock one out of the park against you. And they'll move on. At least that's the hope.
Right.
Next slide, please. Okay, this kind of dovetails back to what we had talked about a few minutes ago, the keys to discovery. Is remember, defense is a team effort. And your lawyer has to know, this is part of hiring the right team. Your lawyer has to know the questions to ask to establish that your driver was 100% correct or nearly so in whatever he or she did prior to that incident. And if they don't know how to ask the questions and prove your case up of the plaintiff, or they don't know how to defend the case, it can make that case a lot more valuable. But it is a team effort. And so that takes you as a company educating your attorney on what you believe happened, why you think it happened, and making sure they understand what you're telling them. And then particularly for the direct claims against the company, you want to make sure that that attorney has everything they need early on to establish that you did everything within FMCSA and industry standards to train and supervise your driver. And in terms of being able to prove FMCSA DOT compliance, just make sure your record keeping is above board, and that you're doing the best you can, and maybe talk to a lawyer or, attend the conference, whatever you can do to make sure that you're keeping your records as best as possible. One of the types of things that I see that occasionally concern me, and they really surprise me, is when I've got somebody that is going above and beyond, and they really are trying to help, but they put something in the driver's file that they thought was helpful, or maybe they put something in the training or the policy they thought was helpful, but they didn't phrase it right. And I'll just use a quick example here. I saw something the other day that said, hey, we are the most unsafe carrier out there. It's a very specialized field. We're the most unsafe carrier out there. And I'm looking at the concerns the risk folks had. And when I look at these concerns in that field, it was, a scratched trailer or a mirror or a stop sign because we couldn't make the turn. I don't think that's a serious problem. That's part of doing business. But now I've got a training outline that says we're the most dangerous carrier out there. And so if the plaintiff's attorney ever sees it, I'm going to have to go in and clean that up. And it's not that the carrier is unsafe at all. It's actually, in my mind, one of the safer carriers I've ever seen. But it's going to be hard to explain to a jury how my opinion is accurate when the safety manager is saying we're one of the most dangerous or almost unsafe. So we got to think very carefully about what we put in writing and how we phrase it. We want to be proactive. Hey, guys, we can do this, and this is what we'd like to do. We don't want to say, hey, you screwed up. We're all screwing. We don't want to phrase it like that. So it's a delicate balance. So let's see here. Let's go ahead and go to the next slide. Okay, so these are some examples of the types of discovery requests that we see. And what we're seeing is a lot of the plaintiff's attorneys, particularly the bigger ones, they share their discovery requests. And so we're seeing recently anyway, a lot of nearly identical requests. And this particular example, it was number 45 out of 109 requests I got. Now, between us, we can sit there and identify, we could all ask the questions we needed to see in discovery, and there'd be maybe 9 or 10 questions because that's all we need. But here, folks are going on a fishing expedition looking for anything under the sun so they can try and develop a case. They're looking for that document that says we're unsafe, or the driver looked like he was high that time, or a text message that somebody put in the driver's note. They're looking for that smoking gun, and even though it's irrelevant, if you give it to them and don't fight them here where it's worth fighting, you're going to wind up having to try more of a larger case. But as an example, this one is looking for all training notes, certificates, and attendance list relative to the defendant driver, regardless of the date issued or originator of such certificates. So something like this, I would say, guys, I'll give you all the training I have on a driver, everything that I have, I'm going to go ahead and give you, but I'm going to object that you shouldn't be asking for something that old or in an unlimited date. But if I have it, I'm going to go ahead and produce it, but I'm going to preserve my objection. But I don't want to go down and argue with the judge on it, so I'm going to go ahead and produce it, because at the end of the day, 99 times out of 100, it's going to make me or make the company, you, look better to be able to just show the training. And this is where y'all's program has been very helpful. So number 46 on this one gets a little bit broader. And they're asking for copies of all past employment inquiries sent to or secured from a former employer, along with all responses. Now, ordinarily, I would expect to see this in a DQ file, so I don't think this is particularly objectionable, and I would go ahead and just produce these, the DQ file and all of our MVR checks that we did early on when the driver was hired. But you can imagine if they're asking these types of questions at number 45 and 46, what else they have to be asking if they have all these other extraneous requests. Now, number 47 gets a little broader. Copies of all inquiries and answers from any organization in reference to the license record of traffic violations and actions directed to, received by defendants, or other organizations on behalf of defendants. So this one is asking for any and all tickets, inquiries, anything along those lines in an unlimited date. And this is where I would start to push back a little bit, and I would restrict the question. I would object, and I would restrict my answer to the last 3 years, because that's all that really matters from an insurance or a DOT perspective in most instances. So I'd say, guys, look, this is what I'm going to give you, and I would try to avoid a fight on it, because it's probably not worth arguing with the judge on it. But at the same time, you don't want to cough up 18 years worth of records, because they're completely irrelevant to whether or not that driver was licensed and qualified on the day in question. Number 48 is another example. All road tests, driver's qualification cards, and it goes on. This one in my mind is even broader, because it doesn't identify just this driver. They're now asking, if you read it the way they wrote it, they're asking for written tests for all your drivers. And so you definitely want to object to that, give them just what this driver had, DOT medical card, and things like that. And then, was there 49 on this one? Yeah. All annual reviews, file summaries, and related documents found in the driver qualification. So something like this, I'm not going to push back on. But, they're looking for any annual reviews, file reviews. And my guess is you guys, most companies aren't going to have an actual summary or for a specific driver. Some companies will, but if you've got it, produce it as long as it doesn't hurt you. And then if it does hurt you, make sure, or you think something is concerning, and then make sure you point it out to your attorney so he or she knows to consider whether or not it should be produced and if it's even relevant to the claims. That's ordinarily how I would fight it. So look, this has nothing to do with the price of tea in China. Why do we need to produce it, Judge? Okay, and so next slide, please. Okay, so training, and this is really, really key to getting cases thrown out early on, is I want to be able to knock out the direct claims against the company. Training, how do I prove it? That comes down to, if you're doing training, make sure that you've got driver attendance, you keeping records of what was shown, if you're showing a video, who attended, that kind of thing. Put it in the driver's file, make sure you record it. Number two, and this is one of the most overlooked and most easy mistakes you can have, is if you have a written policy, and I see this in companies that either somebody went in and they had a policy before they got bought out, or they downloaded the policy off the internet, or maybe it was just something somebody thought was a good idea because it sounded good 30 years ago, but they have a policy. So if you're going to have a written policy, you have to follow it every time. And if you have a written policy and you don't follow it every time, you can bet your last dollar that will be the instance where your driver gets in a wreck and the plaintiff's attorney pulls your policy out and says, look, this is your policy. You knew it was important because it's in your written handbook, and yet you failed to follow it. Judge, this is evidence of negligence and the company's got to stay in, and jury, I want more money. So like I said, you got to be able to prove that your policies were adhered to, and if you don't follow your policies, delete it. 9 times out of 10, you don't need it anyway. Number three, if you've got, and this is something we saw real important the last couple of years, is you had a driver shortage. So you had people that were hiring drivers that they might not have necessarily really wanted to hire, but we saw a lot of instances where drivers were getting in wrecks, and they were maybe good drivers, but for whatever reason, they shouldn't have been hired under the company's policy. And now we're trying to explain how this driver, who shouldn't have been driving according to your policy, actually was entrusted with a truck. So it makes a case that's worth nothing, worth more. And this is something that you need to make your attorney aware of on day one. If you have a driver that you think shouldn't have been hired or something like that, don't put it in writing, but go, even though it's privileged, just call your attorney and say, hey, look, this is our policy. We hired him anyway. He's been a fantastic driver for us. But at the same time, we had this old antiquated policy that we didn't really follow, and just make sure they start working on a workaround for that. And that's easy to do, but you don't want to get blindsided on a company deposition where the plaintiff's attorney pulls it out. Your attorney has no idea what's going on. Okay, so next slide, please. Okay, this gets back to kind of one of the easiest ways to defend yourself as a company in a wreck. And this is also one of the biggest points of contention when I'm talking to drivers, or used to be a point of contention. Now they're becoming much more popular. But when I stop at a truck stop and I'm visiting with drivers, a lot of them hate the idea of cameras, or at least they used to hate the idea of cameras. But more and more I'm getting stories from people that show up that can tell you how the camera saved their tail. And I had a case a couple years ago where an individual called me and said, hey, Peyton, my risk manager told me to call you, and you're never going to believe me. I said, well, I've heard a lot of things. Tell me. He said, well, I'm cruising through, it was a bad area, and a car pulled in front of me, slowed me down. Car pulled up on my left, didn't have anywhere to go. And sure enough, the car in front of me stopped. I rear-ended him. They pulled over. A bunch more people jumped out of the car on the left, jumped to the car in front. Everybody went to the hospital, and now I think they're going to sue us. So sure enough, they did sue. And but he fortunately had just stopped at TA, I think, and had bought himself a camera 2 days before. And he hadn't told anybody about it. It wasn't company policy, but he had a camera there to prove his story. So in that case, I waited until they submitted sworn statements, went down to depose them. And then I sent a copy of the video to the district attorney, and the whole case went away. We didn't do that to secure a legal advantage, but at the same time, even in that particular venue, they didn't care. They didn't want people lying under oath. But without that camera, we never would have believed it, or we never would have been able to prove it, because it's our word against 4 or 5 other people in that instance. But you see that a lot. So practical considerations are, I always recommend a forward-facing camera if you trust your drivers. And if you trust your drivers, you know, the camera will save your tail. This is an example from a case that we had a few years ago. And I'll tell you up front, this camera, had we not had it, that case would have been worth a far larger amount of money. But here, we were able to prove that we were in the right as we approach this intersection. So we can go ahead and roll it through the first time. So here our truck is approaching an intersection. You can't tell here, but there's an intersection coming up. You're going to see some cars passing in front of us, moving left to right. And then as we enter the intersection, the light turns red. But with this camera, we were able to do a couple things. One, we were able to prove that we had the right of way when we entered the intersection, because at a minimum that light was yellow, if not green. It's hard to tell based on the reflected light from that the traffic light. But we can then prove that it turned yellow after we crossed the line. We've established control of the intersection, and yet the young lady turned left in front of us anyway. Now, this particular incident resulted in a fatality. But without that camera, it would have been a he said, she said scenario where we had someone that was deceased and no real liability arguments other than someone's recollection. And that's very, very dangerous. But here we were able to show that we were in the right. And what we did early on was call the police officer and send him a link to that video. He was able to watch it, conclude that we had the right of way, that the young lady was at fault. And so he issued an appropriate accident report that sided with us and faulted the other driver. And as a result, we saved probably millions of dollars on that claim, or at least hundreds of thousands of dollars on that one. So I'm a huge proponent of cameras. I think they save you a lot of money. And I think if you pitch it to your driver or your drivers correctly, that they will appreciate it. Because like I said, if you trust your drivers and you've got a safe fleet, they'll save you money. I don't like the inward-facing cameras. I don't think they offer you anything useful. But there's obviously time and a place in certain instances that you might want to consider. Next slide, please. Okay, accident reconstruction. This goes back to us collecting the ammunition that we need to defend a case. Accident reconstruction sounds simple, but it's very different. A lot of people think that the police officer that went out and looked at the collision and wrote the police report is an accident reconstructionist. The truth is in most cases, they're not. They've gone to basic police school. They may have experience investigating collisions, but they're not allowed under most law or most state laws to talk about the mechanics of how those vehicles came to be, where they are. They're able to talk about only what they saw. So they can talk about, hey, the truck was here, the car was there, this is what he said, this is what she said, but they can't talk about when the truck began to brake, how fast the truck was going, who changed lanes when, other than what someone told them. They can't make that conclusion. Now, a true accident reconstructionist is ordinarily going to be certified by a number of different state or federal entities. And he or she is going to be able to go out there, conduct measurements, look at photographs, maybe use a drone and conduct some aerial surveillance, things like that, skid marks. They're going to be able to recreate the mechanics of that accident. Now, a typical accident reconstruction is going to be, $5,000 to $10,000 up front, but that is an expert in the field that may be your best avenue of proving that your driver was not at fault. And if I have a fatality or a serious injury, or I'm in a dangerous venue, 99 times out of 100, I will recommend that we go ahead and do that and retain that in action reconstruction and get them out there. And that way they're going to be in the best position to corroborate your driver's side of the story. And one of the things you can do to help them is to make sure your driver, or to remind your driver to take photographs, if it's safe to do so, depicting any skid marks he sees, final resting positions, and damage. So when do I spend the money? You spend the money if you have a bad venue or if you have a serious collision or something you're even worried about. If somebody's life flighted, you might think about it. An accident reconstruction will ordinarily save you money long term, particularly if you believe your driver when he or she tells you that this car cut me off, or this car was traveling at a high rate of speed and hit me, or ricocheted this and that. That accident reconstruction is going to be the only way you can actually prove that down the road. So I highly recommend them in any serious collision, because the information that you can get, and in some cases even the video that they can recreate, and this saved us million plus a couple years ago in a bad venue. I had a young lady drive into the back of the truck at 4 o'clock in the morning. She was tired. She was texting. She was late for work, but she died in the collision. And the argument was, well, the back of the truck didn't have the reflective tape the DOT required. Well, we did. It was just dirty. The argument was, well, look, if the tape had been clean, she'd have seen it. So what we did was we actually went out with an accident reconstructionist, and we were able to demonstrate with that young lady, even if she wasn't paying attention up to 3.5 seconds before the collision, she still could have moved into the left lane and avoided it. And we were also able to do a recreation video where we went out there at the exact same time, exact same cloud, weather conditions. And had she been paying attention, she'd have seen the lights on that truck for well over a mile. And there really was no other explanation for how that collision occurred except she wasn't paying attention. And while tragic, it wasn't our driver's fault and it wasn't the company's fault. So those are just some of the practical considerations, and some of the best ways I know to avoid a nuclear verdict is fight the cases aggressively early on, get the company out, summary judgment, get as many claims out on summary judgment as you can. Use it as an opportunity to educate the judge. Don't waste your ammunition fighting over stupid discovery disputes if you can avoid it. And then get an accident reconstructionist out there if there's any question at all as to what happened to them. And I think that's my last slide. Oh, one more. All right. So we've kind of been through this, but practical considerations, make sure if I'm coming in as national counsel for a company, I want to hire somebody that the judge sees on a reasonably frequent basis. I want to hire, because I don't want to be the Dallas guy coming in because the judge doesn't know me. I might take the upper hand or the larger share of the work on the briefing and the arguments if it goes to trial. But at the end of the day, for the day-to-day stuff, I want somebody the judge knows that's discussing the case in front of him or her. That way I'm not the outsider walking in. So hire somebody the judge knows and respects to do the daily stuff. If you've got a fatality, you need to probably get an accident reconstructionist. You need to think about setting a little bit higher reserves and how to aggressively defend this case. And if you don't have a liability defense, there's a couple other options there too. Did your driver fail a drug screen? If you did, you need to know as quick as possible. And then again, coming back to make sure you save your data, save your training, your logs, and then get somebody out there to record the physical evidence at the scene and reach the conclusions, and they can accurately tell you what actually happened. And if your driver's lying or wrong, you need to know. If the driver's 100% right, you also need to know that, and that will save you an immense amount of money long term. Okay, next slide, please. That is the last one. Another shot of old Pete sitting out there in Winchester, West Virginia. Mark, thanks for having me. Any questions, anything I missed?
Well, I'm sure we've got a little bit more to cover here. The bottom line is nuclear verdicts are real, up 900% since 2000. There are some ways to avoid or prepare yourself. Obviously, this post-accident procedure issue is huge. What do I do? Can I get that to the drivers and train them and document that? And giving a statement at the scene, drug and alcohol test, go on and on and on. But we need to keep rolling here. So our next slide is, yes, I want to make sure that everyone listening has the opportunity to take Jay up on his offer for a 30-day demo, free trial. Next slide, please. I think there's a poll you can take. That's myself. Let's keep going. Next slide, please. The poll question. Okay. If you'd like a free demo on being able to produce these documents in case you to prevent that nuclear verdict, just click on the yes. If you'd like to talk to Peyton individually about a concern you've got or a case that you've got, you can press yes. That will go directly to Peyton. He'll contact you. We do have a 30-day free trial on the Workforce Solutions online training and a free demo. If you'll just press the yes button, we'll get right back with you on that. One of the questions that we've got here, let me just pull them. Is there an after accident checklist that I can send my drivers?
So, I mean, you can make a checklist, and I'm certainly happy to help somebody do that or point them in the right direction. But again, that gets back to the policy. And if you're going to have a policy, it's got to be followed every time. And if it's not, the question becomes, why not? The truth is accidents tend to be a relatively fluid situation. So I tend to address that with people, up front is, hey guys, look, this is our general strategy. Let's try and do it. But I really don't like a boilerplate, hey, bam, 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 this is what we have to do every time. I think it creates more potential for harm than it helps. Yeah.
Yeah, I would just add to that. We do have content that's immediately available if you want to participate in the free trial, and you can view the content we have and certainly work with you to customize your checklist. But the answer needs to be yes. You need a package, a crash packet. You don't want to press, post pictures on social media. I've seen that blow up on and discuss a accident on social media. That's definitely something you don't want to get into. We are really running out of time, and I don't want to take up everybody's full afternoon. So I'm going to go ahead and now next week we will have a very interesting webinar on rapid air loss, tire blowouts, how to prevent that, how to react in the event you are involved in a blowout. It's summertime. You've seen all the alligators on the side of the road. Tires are blowing out. We've got a lot of things we can do with that. Peyton's info is available right there. And if there's no other, well, here's one of the questions: is a post-accident drug test required by DOT if the driver is issued a warning citation?
I would say no.
I would say no, yes. Just a citation, a full citation would trigger a DOT drug screen though, correct?
Correct. Yeah, yeah, absolutely. If you've got an actual citation, then yes, but just a warning, absolutely not.
Okay. Well, I'm going to shut her down. Thank you very much for listening in, and look forward to next week. Peyton, thank you very much, and good luck with those summary judgments.
Thanks for having us.
Thank you, sir.